Okay, Bu, we are live now.
Okay. Shall I open this? Or Dr. Lee? How about Dr. Lee?
Yeah. Hello.
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 Shall we start now, Dr. Lee?
Yeah.
Yeah.
I agree.
You can open this?
Yeah. Okay. Hello. So do you hear my voice well? Okay. So dear colleagues, so I'm really happy to meet you. And then today, and then I'm really also like to express my gratitude that to this association. I mean the Indonesian Comparative Law Association, for co-hosting this event with our scholars network. And I would like to introduce a little bit of our scholars network. This name is the Scholars Network on Public Law Issues during COVID-19. So it is called Conflict. And then this is actually based, it started from the one mailing list around 10, 12 people. Now it's now snowboarding, and then it's now around almost 30 people. So all are very distinguished scholars in their own country. So mainly from Asia, like Japan, Korea, Taiwan, also Indonesia, and Thailand, etc. And also there are scholars also from Europe, from Germany, for example, also France, also in Netherlands. Also, there are scholars from also South America and Africa, for example, Colombia and Botswana and South Africa. So, and this is really, wide network. And then the goal of this network is to produce some good legal aspects, especially we will produce writings, either short one or like a longer one, and about this, legal matters, which is caused during this, pandemic era. And then because this virus pandemic seems unlikely to end soon, and then it is a problem that almost every country is now experiencing. And then most countries also say that there will be, so we need to adjust ourselves to this new normal. So that's why, and then right now there are many legal questions regarding this situation. So that's why, and then so if during exchanging our ideas and inspirations, and then we can have more good insight, and then maybe, and then our insights can help the people who are fighting against this COVID-19, or also we can also help the government's reaction in more conform to constitutionalism, and also more proportionate approach, or also as well effective way. So this is our idea of this network. So, and then I'm really glad to join this event, co-hosted by the Indonesian Comparative Law Association. And thank you very much.
Thank you, Dr. Lee. Hi, everybody. It is great pleasure to meet all of you via internet. My name is Susi Haryanti. I'm a professor of constitutional law of Universitas Padjadjaran, Bandung, Indonesia. Last week, Dr. Lee invited me to join with a short discussion with Mr. Satrio to discuss about the possibility to organize a discussion with other colleagues from Asia. And I'm very happy to have or to become a co-host of this discussion. And now I'm also the chair of the Indonesian Association of Comparative Law. This association actually was established 5 years ago in Universitas Indonesia, Jakarta. And one of the founder of the association is Professor Topo Santoso. At the time, he was a dean of the Faculty of Law of Universitas Indonesia. And we just celebrate after 5 years on the 13th of April this year. And we mark our birthday with the launching of our discussion that started with the issue of the Omnibus Law in Indonesia. And the main aim of the association is firstly to develop a curricula on comparative law in Indonesia. And members of the association come not only from the state university, but also from the private university throughout Indonesia. And the members also equipped with a different background. As I said before, that my background is constitutional law, but other members come from the criminal law, and then the civil law, then the IT law, and etc. So the members of our association come from various background of law. And I believe that this would be enrich our association not only with the content of the comparative law, but also how to teach or how to use the comparative law in research, in addition in learning. So this is the very short explanation about our association, and I'm very happy to have a fruitful cooperation in the future with the Scholars Network on Public Law issue, not only during the COVID-19, but I think we also have a very close cooperation on public law for the future. Thank you. And I will introduce you, the moderator of this discussion is Professor Atif Latiful Hayat. He is a professor in international law of Universitas Pajajaran. Please welcome to Professor Atif to guide the discussion. Thank you.
Thank you, Professor Susi. Good evening and good morning, maybe. Thank you for Professor Susi for inviting us to taking part in these discussions. And I am honored to be part of the experts in constitutional law, especially. And I think the issue that will be discussed this evening is very timely issues. Of course, for me, it's a little bit strange because I'm a professor of international law. So I need to read some references on that. And this morning, I read the book written by Professor House entitled Constitution of Law, Legality in a Time of Emergency. So for introducing this discussion, I would like please allow me to read some interesting paragraph of the introductory note by Professor House. Is the rule of law optional for rebel democratic societies? In the wake of the attacks on the United States on 11 September 2001, the Bush administration seemed to say that it is, and in the wake of the attacks of London in July of 2005, Tony Blair has indicated that the rules of law is a luxury, dispensable when the going gets rough. In particular, he has indicated that judges have to be reined in from their disposition to enforce the rule of law against the executive. even if this requires both legislating how they are to balance liberty against security and amending the Human Rights Act of 1998. In contrast, the Spanish government elected in the immediate aftermath of the attacks on Madrid on 11 of March 2004 did not see fit to renege on a commitment to the rule of law. It seemed to me that emergencies are often used as an excuse or maybe as an emergency exit from the rule of law. In fact, in my understanding, the emergency only provides the possibility to make some relaxations of rights and obligations, and the government should be responsible and accountable for all decisions they make. For example, a couple of weeks ago, the Indonesian government issued a government regulation in lieu of law on financial stability to mitigate some economic problem affected by the 19 COVID outbreak. But there was a provisions which had been widely criticized by the public in Indonesia, especially by the experts of constitutional law, especially Professor Susi, who is the new opposition of the government. Why? Because the provision stated that the government could not be held responsible for all its decisions during the emergency. Is this really the way it should be? So for these reasons, I note several important points that we will discuss this evening, namely emergency power in the constitutions in different countries, including in your country, the speakers. What is the procedural substantive limits of the emergency power? Can the issuance of the emergency power be reviewed by the high courts, such as constitutional courts? And is there any precedent of that? If the emergency power be reviewed, what is the standard of the review? For example, there is a proportionality test in that case. So, and now we have 2 speakers and 4 discussants. And I would like to invite the first speaker, Professor Susi Dwi Haryanti from Pajajaran University. 10 minutes, maximum 15 minutes for Professor Susi. And the floor is yours, Professor Susi.
Thank you, Professor Atif, for inviting me to present my presentation. Before that, I'd like to share my PowerPoint. This is the title of my presentation, that is Fighting COVID-19 in Indonesia, a state of emergency through the back door. This is I put a question mark on this title because of the several reasons that we can know the answer of this question on my presentation. This is the timeline of the entry of the COVID-19 in Indonesia. So in February, the Indonesian government dismissed coronavirus risk. It seems at the time the government want to ensure the people that everything is okay. So maybe the virus cannot hit Indonesia. So everybody's calm. Also in February, the government introduced policy which made it easier for foreign tourists, including from China, to travel to Indonesia. However, in the early of March, the first patient of the COVID-19 was published by the president. And by early and mid-March, the government denying the existence of the COVID-19 case in Indonesia. However, At the end of March, the patient of the case of the disease is about or nearly 1,000. Then, and this is too contested meaning of emergency to the virus. At the end of March, President Jokowi considered to establish civilian emergency status, or in Bahasa Indonesia, we call darurat sipil, to fight the pandemic. However, the civil society group rejected the proposal and urged the government not to declare the emergency situation, but they urged the government to declare health emergency status. So they urged the government to declare health emergency status rather than civil emergency status. Now, what is the civilian emergency status? Actually, this status is regulated by government regulation in lieu of law number 23 of 1959 on emergency situation or emergency law. In Bahasa Indonesia, we call government regulation in lieu of law as Perpu, or Peraturan Pemerintah Pengganti Undang-Undang. And it uses two constitutional norms as its basis, namely Article 12 and Article 22 of the Constitution. This is quite different based on the Indonesian Constitution. Article 12 grants the president exclusive power to declare the state in emergency during a war or conflict situation or in terms of the natural disaster. However, article based on the Article 12, then the president have the exclusive power to declare state in emergency. In constitutional law, the theory of the constitutional law in Indonesia, we call Article 12 as the extraordinary measure. This is what we call for the Article 12. However, Article 22 allows the president to introduce government regulation in lieu of law or Perpu based on his or her subjective assessment toward what is the exigency situation. So that's the there are two kinds of constitutional norms in Indonesia that regulate that the different type of emergency. Now we move to Perpu number 23 of 1959, that Perpu divide the emergency status to become three different types. The first is civilian emergency status, then the second military emergency status, and the last is the war emergency status. And what are the consequences of the declaration of the emergency status? There are actually four consequences of declaring a state in emergency situation. The first one is the management of governmental affairs. If the government or if the president declare the civilian emergency status, the management of governmental affairs or the person who is in charge is the civil servant or the civil official. However, in the situation of the military emergency and the war emergency, then the military official will be in charge to handle the management of the government affairs. And the second consequence is the making of regulation. And the third consequence is human rights implementation. And all of us know about the human rights implementation. The government can limit the human rights in that situation. And the last consequences is the law enforcement. Now we move to health emergency status. This is the status that urged by the civil society organization, and the status is regulated by law number 6 of 2018 on health quarantine, and it is based on the Article 28H of the Indonesian 1945 Constitution. Basically, it relates to the guarantees of the right to health. And the activation of this status then allow the government to limit people movement as well as social and religious activities carried out under the situation through the establishment of large-scale social restriction. However, the activation of this status does not allow the government to limit freedom of speech and also the works of other state institutions, including the parliament. And this is because the main purpose of this mechanism only deals with how to overcome health crisis. And as Professor Atik mentioned earlier, at the end, the President Jokowi declaring health emergency status rather than civilian emergency status. This is the 21st of March. However, some of government acts dealing with coronavirus, it seems to apply security approaches, as in the situation of the civilian status of emergency. And what is the reason behind this statement? I think that because the government, the chief of the Indonesian National Police, issue an internal regulation that empowering the police to prosecute acts of defaming the president and the act of criticizing the government policy. And this regulation potentially limit freedom of speech. But the most fundamental is that this internal regulation seem to contradict with the decision of the Constitutional Court of Indonesia that already invalidated the norm of defaming the president as a criminal to become the criminal act. And the second, the president introduced emergency legislation, that is what we call Perpu, based on Article 22, that known as Perpu number 1 of 2020. And this law enacts economic and finance policy that adopted by the government to handle the COVID-19. However, this is Article 27 is among, I think that the critical article on that Perpu, because it deals with the law enforcement. Article 27, paragraph 1, for example, state that all acts are not classified as state's financial loss. And paragraph 2 regulate prohibition of any acts against government official through civil and criminal suit. And all implemented acts and policies according to paragraph 3 of the same article are not subject to the administrative court review. And as a result of the issuance of the Perpu number 1, 2020, then some of the civil society group challenged it before the Constitutional Court. And I think I heard that the Constitutional Court already conducted the preliminary, preliminary examining about this application. And the argument, the main argument of that group is that Perpu paves the way the use of unlimited power of the government by eliminating people power to check, or by eliminating not only people power, but also the power of the court to check the government. Thus, it violates the 1945 Constitution, which guarantee independence of the judiciary as well as the principle of the rule of law. And this is the current development. The Perpu is still debated by the House of Representatives, but it seems that it would be approved by the members of the House, as the majority of the House has a very close tie with the government under the Jokowi administration. Thus, there are two ongoing review mechanisms. The first one is political review by the House to assess whether exigency requirement has been met, and the second review conducted by the Constitutional Court. And actually, since 2009, the Constitutional Court has affirmed that it has a review over the emergency regulation. At the time, Professor Mahfud MD was the Chief Justice of the court. And interestingly, now, Professor Mahfud is a coordinator minister for politics and then security and legal affairs. And however, the court tends to use a very restraining approach when it heard emergency legislation. So up until now, the court never invalidated emergency legislation. And this is the underlying issue, I think, in Indonesia, dealing with the review of the Perpu. The first one is whether the court applies its independency and its impartiality. Why I raise this issue, as I mentioned before, that now Professor Mahfud MD is the minister, a part of the government, whereas in 2009, Professor Mahfud is the Chief Justice of the Constitutional Court. So we will see to what extent that the Constitutional Court can uphold the principle of the independency and impartiality when it reviews the Perpu. And the second issue is that, already mentioned by Professor Atip, whether the court plays a more active role, whether the court play more judicial activism rather than judicial restraint. And if so, it is possible for the court to apply the proportionality test. So this is my short explanation about the current situation in Indonesia now, in particular dealing with Perpu number 1 2020. Thank you, Professor Atip.
Thank you, Professor Susi, for your interesting, inspiring, as well as intriguing presentations. For your information, the government regulations in lieu of law number 1 2020 is already approved by the House of Representatives by the DPR. It is very interesting. Now I invite Professor Chien Chin Lin from Academia Sinica, Taiwan. Professor Chien, you have the floor.
Can you see my screen? I mean, there's a PowerPoint file. Is it okay? Okay, yeah. Thanks, Professor Atip, Professor Susi, and Dr. Lee for inviting me here. It's my great honor to be here. And in the following, maybe 15 minutes, I'm going to introduce the the COVID-19 situation in Taiwan and the emergency decree or not, in Taiwan. So I guess I will start from the current situation in Taiwan. As I said before our discussion, I will compare to other, Asian countries or Euro-American countries. Taiwan is, the COVID-19 is, I would say, relatively under control in Taiwan. We have only something like 400 confirmed cases among 23 million people. And I think, as I said, shops are open, restaurants are open, movie theaters, cinemas, everything is generally normal as usual, and schools are open as well. So, but that doesn't mean that we don't have, many controversial issues and emergency, whether the government should or would issue emergency decree in Taiwan has been a hotly debated issues in recent years. So in the following, I'll introduce, the emergency decree in Taiwan. I would say, constitutionally speaking, Article 43 of the Constitution, the Constitution of Taiwan is entitled, strangely, the Constitution of the Republic of China. So in our Article 43 of the Constitution, it basically stipulates in what circumstances or under what preconditions can a president issue an emergency decree. So in Taiwan, the emergency decree, the emergency power is exercised by the president. But the original constitution is actually, I would say, very strict in this sense, in the sense that it actually has five preconditions to be met for a president to issue any emergency decree. And since it is very strict, and since the Constitution was enacted in 1947, when you can say when Republic of China was still in mainland China, fighting the Chinese Civil War against the Chinese Communist Party, because the PRC was established in 1949. So at that time, this constitutional clause that tried to limit the presidential power to issue an emergency decree was almost immediately suspended by another, you can say, quasi-constitutional amendment. And that is the second one on the screen, which is what we call the temporary provisions effective during the period of national mobilization for suppression of the communist rebellion. Anyway, we call it temporary provisions. So at that time, since the Nationalist Party was fighting against the Communist Party, so the ruling party issued these temporary provisions to, you can say, suspend Article 43 of the Constitution that I just mentioned. And in this temporary provisions, it greatly expanded presidential power to issue emergency decree. So under the temporary provision regime, the president has almost unlimited power to issue a presidential decree. I will not bother you with the details that I listed in the short essay, but sufficient to say so that the temporary provisions has greatly expanded the presidential power. And given the expansion of the temporary provisions, or you can say given the authorization of the temporary provisions, the emergency power was abused, I would say clearly abused in the past, or you can say in Taiwan or in Republic of China's history. So since 1947, when the Constitution was promulgated, the president has issued emergency decrees 11 times. Someone say 12 times anyway, but that's either 11 or 12 times. And 7 of them was issued when the Republic of China was still in mainland China. And the last 4 times was issued after 1949, when the Republic of China was retreated to Taiwan. And after 1949 means when the People's Republic of China was established. So after the Republic of China moved to Taiwan, Taiwan has experienced, you can say, an authoritarian period for, I would say, roughly 40 years. So the democratization in Taiwan actually began in 1987. So in the early 1990s, the Taiwanese people amended the constitution and issued the constitutional amendment, which is officially known as the additional articles of the Constitution of the Republic of China, which is the third entry. And in Article 2 of the additional articles, you can say in Article 2 of the constitutional amendment, it strike a balance between the original Article 43 of the Constitution and the temporary provisions. So it somehow expanded the presidential emergency decrees and in a way restricted. So it is somewhere between the original constitutional design and the temporary provisions in terms of the scope of the presidential emergency powers. And as I said, it was abused. Let me jump to the third slides. As I said, it was abused in the history of the Republic of China or in the history of Taiwan. It was used 11 times, mostly in China and 4 times in Taiwan. And the 4 times are issued respectively in 1949, 1978, 1988, and 1999. In 1959, it was because of a flood that kills, hundreds or thousands of people. And in 1978, the emergency decree was issued because the United States, as you may know, recognized the People's Republic of China as the only legitimate Chinese government or the Chinese regime in the world. And, it cut the diplomatic recognition of Taiwan or of Republic of China. So the government said, well, it was, significant and may cause, national security issues or something like that. So they issue another emergency decree. And in 1988, it was because the death of then president, basically a dictator. Because of his death, the government or his successors issued emergency decree in case that there are social chaos or anarchy or something like that. And as I said, in 1987, the democratization in Taiwan began. So lastly, in 1999, the government, a democratically elected government, issued the latest emergency decree because there was an earthquake that killed, I think, more than 2,000 Taiwanese. So that's the last time. So it is important to note here that an emergency decree has never been used after 2000. And 2000 is important because 2000 is the first year or the watershed in which Taiwan's opposition party firstly won the presidential election, which means that in year 2000, Taiwan has gone through party turnover. So that's it. And after the latest emergency decree was issued in 1999, so in 2002, the Constitutional Court faced the issue, whether an emergency decree should, or whether it is constitutionally reviewable, it is judicially reviewable or not. And the Constitutional Court decided, oh yeah, for those who are not familiar with the Taiwan's system, well, basically the Taiwan's legal constitutional system is very similar to that in Indonesia and in Korea, that we have a Supreme Court and a Constitutional Court. And the Constitutional Court is responsible for interpreting the Constitution, and it has the power of judicial review to strike down legislations on constitutional grounds. So in 2002, our Constitutional Court said clearly that an emergency decree is judicially reviewable. That means that the Constitutional Court can review the constitutionality of an emergency decree, but it will be, the Constitutional Court will be soft in that sense. It will not be too demanding. At the same time, the Constitutional Court also said that an emergency decree should pass proportionality that Professor Sushi just mentioned as well. The court said very clearly that even an emergency decree should pass the proportionality test. However, in 2002, in what I call in the Constitutional Court decision number 543, the court did not specify or did not elaborate how it will apply proportionality. It simply said an emergency decree should pass the proportionality, but it does not specify or explain, for example, how necessary an emergency decree should be, or how it would balance the cost and benefit of emergency decree. It does not say so. It simply said, yes, proportionality should be applied. That's it. And as I said, after 2000, Taiwan has never, the Taiwan president has never issued an emergency decree. But as we all know that in 2002 and 2003, SARS became an important issue in many Asian countries, as well as Euro and American countries. And at that time, many people had suggested the then president to issue an emergency decree, but the president denied. And the reason the president denied is because the legal framework was enough. Basically, it's called the Communicable Disease Control Act, the CDC Act. The president said, well, our legal framework was good enough, so I do not need to issue an emergency decree. But the CDC Act actually, you can say, in a sense, it gave the government many powers to deal with those emergency situations. So the constitutionality of that act was petitioned to the Constitutional Court, and the Constitutional Court take the case and became what I'm going to discuss, and became the Constitutional Court decision number 619 in 2011. So in 2011, the court once again said, the CDC Act, that is the Communicable Disease Control Act, is constitutional, but it also said that the CDC Act should pass proportionality. And this time, the court is very clear, what is legit. It basically applies proportionality in a very typical way. It examining whether the law pursues a legitimate government interest, and examining whether the means and the ends are reasonable, whether the means, whether they are less restrictive means to achieve the same ends, and it balance the gains and the cost of the law. But still, the Constitutional Court uphold the constitutionality of the CDC Act. That's in 2011. And as we see that, since I think the early January this year, the COVID-19 became a global issue in not only in Asia, but also in United States and Europe. So I would say, unsurprisingly, many people in Taiwan, including many Congo scholars, had suggested that the president should issue an emergency decree. So, I mean, there are different debates here. I'm not going to discuss in detail the debates in Taiwan, but anyway, many Taiwan scholars have suggested that you should issue an emergency decree because you now have too many powers. And the President Tsai, the current president, denied to issue an emergency decree based on 3 reasons. And her first reason is because, as usual, the current framework is good enough, which includes the CDC Act, the Communicable Disease Control Act, and a COVID-19 Special Act that was enacted early this year, I think in February or something. So that's the first reason. The legal framework in Taiwan is good enough, she thinks. And the second is that the situation is not that urgent in Taiwan, actually, because as I said at the very beginning, the COVID-19 is, I would say, is quite under control, at least in Taiwan. So she said, well, since it is not emergent in a sense, so there's no need, I don't bother issuing an emergency decree. And what is interesting is I think that her third reason is, I think it's because of that. I also said that because emergency powers in Taiwan or in the history of the Republic of China has been abused in the past. And she said that unless it is absolutely not necessary, she does not want to, invoke emergency powers, because if I invoke emergency power in this situation, which is not that emergent, president in the future may abuse this power again. So based on these three reasons, she rejected invoking emergency powers. And of course, there are many constitutional controversies persist. For example, even though she did not issue emergency decree, the COVID-19 Special Act actually grants the government expansive powers, to track, people's phone numbers, to prohibit export, to force quarantine, to something like this. So there are many human rights concerns that many, I would say, constitutional scholars think that we should discuss in the future. So I guess my presentation would stop here, and I'm looking forward to your questions and comments. Thank you.
Thank you, Professor Chains, for your interesting presentation. And one point of interesting to me is why the government of Taiwan not to issue emergency decree. There are two important reasons: because of historical abuse of emergency power and human rights concerns. I think it's very interesting point to me. Now, I invite discussions. We have four discussants: Professor Ejima, Dr. Lee, and Mr. ATP Bonsin, and Mr. Lutfi Chakim from Indonesia. And the speakers have 5 to 7 minutes for comment. And now I invite Professor Ejima from Meiji University, Japan. Professor Ejima, you have the floor.
Sorry, can you hear me now?
Yes.
Good. Thank you. First of all, it's a great honor and such a pleasure to be a part of such a fantastic event. And I also would like to greatly thank to the organizers, fantastic initiative and very well organized webinar. Actually, it's one of the first webinars I participated in a discussion. So well, time is money, so I should start now. Well, as for the comparative material, I would like to introduce some Japanese situation. And also I would like to comment on two fantastic papers. So about the Japanese situation, well, if I characterize the Japanese government approach, it's very slow and soft approach. So why start? That's a really interesting question. But I wrote a short essay for the Verfassung blog, and it will be published in a few days. So I will give you a link to all of the participants later. So I try to rather summarize what's going on in Japan. And also I try to make an effort to respond to the points which moderator nicely organized. So first question, emergency power in the Constitution of Japan. There is no clause in the present Constitution, which was adopted in 1946, as you might know, that after the World War II. But the previous Constitution does have clauses to use the emergency power, and which was actually used, for example, to restrict the freedom of assembly and even try to punish by death penalty to control the political dissident. So to some degree, this might be the similarities between the other countries that Japan has a past in which the emergency power was misused or abused. Therefore, the people in general very concerned about having the emergency power. Therefore, Well, the in absence of the emergency power can be interpreted in many ways, but the rather liberal constitutional scholars consider this is a good sign not to have an emergency power in the constitution. But at the same time, it could be another argument that well, if there is no clause, then if something extraordinary situation happened, then what should we do? And without any clause, this is more abuse of the power. So there are 2 points, whether we should have the emergency power in the constitution or not. Because of the past, we don't need to have one, or because of the past, we need to have the better one to prepare for the exceptional situation. But the current situation, are there any legislation to cope with the COVID-19? Yes, the Japan has one. This is called as the Act, it's a bit long title, the New Influenza Special Measures Act 2012, which was adopted in order to cope with the new type of influenza pandemic. And this act can give a power to the Prime Minister to declare a state of emergency. And once this state of emergency was declared, then the local governors, the prefectural governors, can specify the shops and facilities to be closed. And they can request those shops and facilities to be closed or to stop the events. And at the same time, the prefectural governors and also, of course, central government, prime minister can request the residents to stay at home. The problem is there is no penalty. So it's a sheer request, and it's really up to them whether they follow the request or not. There are interesting cases. Do you know pachinko? It's a Japanese gamble machine, very noisy place and very closed. And some people are really addicted. And of course, every prefecture governors ask the pachinko parlors, please close. And majority of the shops closed. But of course, always there are some exceptional ones, and they kept open. And then what the governor can do? Nothing other than just publish names. So it's like a naming shaming approach. But then what happened? The pachinko addicts rushed to the parlors, to such a limited open parlors. So actually this, without penalty, sometimes it's really difficult to enforce the request. But overall, well, in 3 weeks, gradually these social norms, social distancing policy are becoming a really new social norm. So many people really actually follow the social norms. And right now, the speed of the confirmed cases is decreasing now. So we will see the social distancing policy totally depends on social pressure rather than penalty would work or not. This might be a very interesting case for the comparison. And then probably other points. So what is the limit of the emerging power? So I don't know whether I can call it as emergency power because it's soft. But anyway, if I consider it, this new Influenza Special Measures Act as can give some special emergency power, then first of all, Prime Minister has to declare this state of emergency by defining its period, an area, and an overview. And the period cannot exceed 2 years, and its extension is possible for 1 year as maximum. And probably this third question, that the EPN current COVID-19 situation, this already I mentioned. So slowly social distancing policy is accepted by the general public. And another concern is now more important to be noted, that the social pressure sometimes works as how can I say, we call it as a self-police. situation. So some people think that they have a right to criticize the other people who don't obey the rule by sort of put the names and pictures on the SNS. So this is another private naming shaming system. And as you know, because of the internet society, because of the use of the SNS, sometimes it is more harmful to the people, particularly the violation of the privacy and so on. So this could be another concern in the sometime. And then the probably fourth, fifth, and sixth questions. Can the emergency power be reviewed by the highest court? Yes, of course. But as I said, the measures themselves are quite weak. So it may not be the really big constitutional issue. But anyway, all the courts can have the judicial power, so they can check whether the act and also the measures taken by the public authorities under this act can be reviewed by the courts in general. Although I have to mention that there is an important difference between other countries, particularly the Indonesia and Taiwan, and of course Korea and Japan. Japan does not have a constitutional court. So again, this is more difficult probably for the general public to bring the case to the court because you need a specific case. You need a good case. You can't have the sort of abstract review just checking the legislation or some government policies at all. And then if the emergency power be reviewed, what is the standard of the review? I think just the ordinary standard of review should be used, including the principle of proportionality. Although the Japanese Supreme Court has not adopted openly the principle of proportionality, but behind the scene, they must have known the principle of proportionality, and in some cases, the constitutional academics can sort of read it out, principle of proportionality. So slowly I realized that how many minutes, or do I use up all my time?
Time is up, Professor.
Okay, so just last one sentence.
Okay.
By hearing all the cases in the Indonesia and the Taiwan, I realized that even your countries has not used a classic emergency power, and they rather use the more specific health emergency power, which is similar in Japan. And I think it is time to think of the concept of emergency power, which was born in the rather 19th and 20th century, when the state sovereignty and the state should fight against the other states. And so the state of emergency was rather discussed in the situation of wartime or civil war. But the current situation is quite different. Therefore, we need to differentiate from the previous situation and the current situation, which would be really healthier to discuss. Thank you.
Thank you, Professor Ayima. And now I invite Dr. Lee from the Korean Constitutional Court. Dr. Lee, you have the floor.
Hello. Yeah. Please wait a second. Then, yes. Here my. So, and then thank you for all speakers for your wonderful, insightful speech. I just briefly, comment, and then also I would like just mainly introduce what is happening in Korea and what is the situation, legal situation in Korea in terms of COVID-19. So, so you probably see this text, right? So, and then briefly about this 5 point. So in Korea, there is a emergency power in the constitution. Yes, there's clause. The first one is emergency financial order, and it is Article 76, and then paragraph 1. And the other thing is emergency order. So you can say also emergency decree. The Article 67 saying, but paragraph 2. And then of course we also have martial law, clause in the Constitution. I haven't written down this one in this number, but it's also in the Constitution. So this is, so the martial law is the highest level, but normally this emergency decree we say emergency financial order or the emergency order. So about this, actually, I wrote also in one blog post in this in Fair Parsons blog. So that's why if you type my name, Sungmin Lee, and then just fighting COVID-19 in Google, then you can find easily about this. So that's why I don't want to bother you about in detail, but so I will say very clearly about the answer. Yes, the emergency power is prescribed in Korean Constitution law, and then what is the limit of the emergency power? Yes, there is a procedural limit and substantive limit in the text of each clause. So each is also very similar to Indonesia, but maybe in detail it's different, but there are some similarity. But and then I would also like to say that like Taiwan, we have authoritarian path. So that's why it is in the text is rather it is in detail prescribed, and then also there's some let's say some reluctance of the government to issue this emergency decree. Actually, this is power of the president, but president seldom use this power. But there was actually the case in 1990, around 1993. Yeah, so I will explain it later about this precedent. Anyway, and then so emergency power in this COVID-19 situation in Korea, actually, so it is not issued. So because government is reluctant to use this power because right now the government is more pro-democratic government, and also after this SARS and also this MERS, this disease in Korea, because we already experienced several years ago about this kind of disease situation. So we have prepared some special law. It is called IDCPA. It is Infectious Disease Control and Preventive Act. And then we have this special body in the government. And when this virus situation is going higher, then this center has in control of this whole governmental action. And then that's why. So in this act itself, it functions as like kind of emergency statute. So and then so yeah, so Korean situation right now, so emergency power is no need for now, but there is a statute, and then this statute functions well in this virus situation right now. And then I also wrote down some about the controversy in Korea, a political controversy, because some opposition party want to make this some virus situation as an issue, and then they claim that presidents should use emergency power more, and then actually but from this kind of argument is not match the constitutional the limit or constitutional conditions. So that's why even one mayor in the opposition party in the Daegu city, he apologized about his ignorance of this legal knowledge. And then so I explained this in this text. You can find it in Fair Parsons blog. Okay, about the point 4 and 5. So can the issuance of the image power can be reviewed by the Constitutional Court? Yes. And then we have precedent. And then it is case number 93, 186. And then it's and then so yeah, and then actually court accepted this case, and then they reviewed about this emergency emergency financial order actually, and you can say also emergency financial decree. And then here is the contents briefly. It is abstract. This is very summarized result. So when the court was asked to review the constitutionality of the emergency financial economic order, and then this is case in 1960 in the 19 it is application is 1993, but the decision was 1996. So it took around 3 years to make this decision. The court explained that even though there is some concept about prerogative action of the president, and then it can be a very highly political decision, but it also should be subject to the judicial review of the court. And then if it is directly infringed upon the basic rights of the people. So this is argument. Why court can review this one? Because it can directly infringe upon the fundamental rights of the people, constitutional rights. And then another argument is this order or decree has the same effect compared to the parliamentary statute. So that's why this must be bounded by the constitution, and this can be reviewed by just like any statute. So this is the second argument. So that's why maybe this can be some kind of universal kind of argument for any constitutional court if you have some similar this power in your constitution. So and also some scholar also said that the position of this constitutional court actually puts some a break to the bad custom of justifying present ultra virus act on the ground that is prerogative action of the president. So that's why it is very landmark case in Korea already in 1996. So that's why it is a big development in Korea in terms of rule of law, also constitutional regime. So that's why I would like to also share this information to you. So also, I also get impressed by the the Taiwanese precedents. So that's why this kind of precedents can give some inspiration to other countries, and we can exchange our experience. So, okay, this is my first comment. Thank you.
Thank you, Dr. Lee, for your interesting comment. And now we invite Mr. Ativi Bonsin from Thammasat University, Thailand. Mr. Ativi Bonsin, you have the floor.
Thank you for the opportunity. I'm so happy to be here. And it's a fascinating issue, fascinating webinar that we are having. And to keep it short, I just want to discuss first about the overall situation when we have to deal with this COVID-19 pandemic, and what we as the public law scholars should talk about. And I think it's very interesting now that when we talk about this kind of emergency situation, emergency powers, in many countries, we often associate this emergency with the kind of national security question. And when we finally have to deal with the health emergency, the pandemic, we have this dilemma that's just like, how should we deal with this emergency? Should it be the same thing as when we deal with the national security, or should it be something entirely different? And this thing, apart from countries like Taiwan, who has some experiences in the past on how to deal with an epidemic, most countries have no idea how to deal with it. And so I think this is a very fascinating question indeed. And to bring the attention now to the case of Thailand, as nicely framed by our organization here, the questions that I should try to answer. Okay, the first one is, how is the emergency provision in the Thai constitution? In Thailand, actually, we don't have that kind of state of emergency clause that give like acquisitive power to the executive, to deal with anything that could happen during the emergency. But we only have this clause on emergency decree. So pretty much like in Taiwan, the government has the power to issue the emergency decree according to the Article 172 right now in the Constitution. And compared to the Taiwanese constitution, you could see that the emergency power, the power to issue this emergency decree is very relaxed and I think very forgiving for the government. So there has really been no debates whatsoever for the emergency decrees, three so far that the government has issued. And these emergency decrees are not actually mainly dealt with the situation right now. They are just dealing with technicality in law, in trying to give the loan to the government and deal with financial difficulties in the country. In fact, what the government has done so far has been relied on the another regulation, another legislation, which is the emergency decree that has been issued a long time ago in 2005 on how to deal with emergency situations. And based on that legislation, the government has almost tremendous powers because the decree was originally designed to deal with the insurgency in the southern part of Thailand, the terrorists. And so far, this decree, this declaration of emergency power have been dealt with only national security issues, like when we have the political turmoil in the past with the protesters. So it's the first time that we have been dealing with this pandemic. And so far, because the issue of COVID-19 is so terrifying, people have not really trying to argue with the government whether they could do it. And part of that, I think, is because we have been quite effective in dealing with the virus, that people feel like, okay, you can do whatever you want as long as we are safe. So right now we have the curfew, we have the centralized power center in the prime minister, but no one really trying to fight against these restrictions. And then as to questions of the judicial review, I have to say that, this law, this emergency decree that we are using is really prohibitive in terms of the judicial review, because as some might know, in Thailand, we have this fantastic administrative system, administrative court system, but this emergency situation decree actually prohibits the court from reviewing any cases arising from the use of the power according to this emergency decree. And instead, once you prohibit the administrative court from involving in, then the ordinary civil courts have to do the job, and then it's very difficult for them to use proportionality or something like that, because that's not something ordinarily judges do on a daily basis. And so I think this is very interesting, because when compared to the case of Indonesia, that you have a new law that kind of have the same prohibition or restriction about judicial review from the administrative court. I think you could look at our case in Thailand to see how it goes. Okay, and I think I've spent enough time, but I just want to summarize here that the situation in Thailand is rather different, because we have in the past dealt with emergency through coup d'etat. Whenever we have any emergency, we just have the military, staging the coup d'etat and then gather all the power. And now that the government is kind of from the past coup d'etat, so that's really not real discussion about what we should do, because we kind of feel like it's already like the government already has concentrated a lot of power within them since the last coup d'etat and having their own constitution. And so this concludes my discussion for now. Thank you.
Thank you, Mr. Abiponsins, for your interesting presentations. And now I invite the last but not the least speaker from Indonesia, Mr. Lutfi Chakim. Lutfi, you have the floor.
Okay. Hello, everyone. Thank you so much to the great organizers, moderator, Professor Atip, and to all presenters, Professor Susi and Professor Lin, for giving a great presentation on COVID-19 and emergency power. Actually, there is a famous quote regarding this issue saying that the emergency time call for the emergency or extraordinary measures. This quote is to justify when the government used the emergency power to fight the spread of the COVID-19, which can save millions of lives. But don't forget, they also come with human rights issues, such as limiting of freedom of assembly, freedom of movement, the right to privacy, and so on. Basically, a state of emergency implies that the government has the right to limit or even derogate from some basic rights as recognized by the international human rights law. And the international human rights law already make a distinction between the limitation model and derogation model, which can be found in the Siracusa principle. But what I'm going to say is that, however, when the government uses the emergency power, there is a global worrying around the world that the government not only can use the emergency power, but also potentially abuse it, such as limiting freedom of speech, targeting journalists, and criminalizing people who have different views with the government. It is therefore, in this context, I'm gonna say that the more power of the president has, the more court's role should be employed. So my main concern is to identify what should be the role of the Constitutional Court for the protection of human rights in time of pandemic. Of course, Constitutional Court must intervene actively during the pandemic of crisis. As we have seen, the Indonesian Constitutional Court has constitutional review mechanism in the abstract form, so everyone can bring the case to the Indonesian Constitutional Court. And I just got the news that the House of Representatives just approved the government regulation in lieu of law. So automatically the case will be lost its object in the constitutional review case. But we have this kind of constitutional justice to protect the citizen constitutional right, as well as in Korea, for example. Korean Constitutional Court has constitutional complaint mechanism against the government actions, which is the individual citizens can bring the case when he or she fundamental rights has been violating by the fundamental government actions. But Indonesia, as well mentioned by the Professor Susi, already have some jurisprudence in dealing with the emergency law, such as in 2009, for example, 2009 cases. But of course, comparatively in Taiwan, in 2002 cases, also mentioned in the proportionality analysis, Korea also has the emergency decree cases, as well as Thailand case. But what I'm gonna say is that when dealing with the emergency decrees, the Constitutional Court or the Constitutional Justice or the Supreme Court in Japan should focus on the proportionality analysis. The proportionality is best known as a tool developed by the court originally or historically by the German Administrative Court and then developed by the German Federal Constitutional Court, and then it's adopted by many countries. But the proportionality analysis is just a tool, not a mathematical method. So when the certain government limitation is deemed necessary, it must comply with the following criteria, such as suitability. In this context, it must be based on one of the grounds justifying limitation. Does it public health? And this step is to answer the question such as, is the limitation of the citizen's fundamental right related to the prevention of the spread of disease? And the second step that we usually use is the necessity. It must be respond to the social need. It is the answer, this step is to answer the question whether the government action is necessary to achieve the objective. The next part is usually we apply the legitimate aims. Of course, fighting COVID-19 is appropriate objective, but defining the objective is not a straightforward. It can be fighting COVID-19 without causing harm. And the last one, we usually apply the balance. Must be appropriate to the aims. It is also to answer the questions such as, does the government action in fighting the spread of COVID-19 outweigh the significant interference with the individual liberty caused by the limitations? When take a look in the European countries, for example, to make an effective operation of the European Convention of Human Rights, the European Court of Human Rights may grant the state a margin of appreciation based on the principle of subsidiarity. But of course, my concern is that viewing the pandemic crisis through the lens of suitability, necessity, legitimate aims, and balance is a way to understanding whether the government measure are an appropriate response to the pandemic. As Professor Susi has raised our concern that judicial independence should be applied, because without judicial independence, it's very difficult to have an effective protection of the individual fundamental rights. So it is worth emphasizing that even where rights are limited in times of emergency, the rule of law continues to prevail and there should be no legal vacuum. But as Professor Susi also has a very good message about the constitutional provisions in Indonesia, as well as the Indonesian government response to the pandemic, but there are actually 3 related regulations as a formal response to the pandemic. The first is about the Presidential Decree number 11, year 2020 on a stipulation of public health emergencies. The second regulation is the Government Regulation number 21, year 2020 on large-scale social limitations. And the last one is the Government Regulation in lieu of law, which is just approved by the National Assembly become a permanent law. So of course, finally, to conclude that we have a constitutional justice to make sure that all laws, including emergency laws, will not violate the constitutions and fundamental rights of citizens. And finally, let's fight this disease and then get back to the normal as soon as possible. Thank you so much.
Thank you, Lutfi Hakim, for your very interesting comment. Yeah. And because of time constraints, because shortly we Indonesian Muslim will have a break for our fasting. So we invite two persons for asking the questions either to the speakers or discussants. And for those who want to ask, please raise your hand. Yeah. For questions. Okay, because I have a question from the chat room from Ibu Ina Junaina, UTM Malaysia. He asked about human rights. I would like to ask if human rights, for instance, the rights to life can be redefined under an emergency power, specifically in pandemic COVID-19. Who will answer the questions for the speaker or this discussion? Okay, Professor Chin from Taiwan will answer the questions.
Yes, I would say it is also one of the highly debated issue in Taiwan as well, in that, you know, whether human rights are redefined, quote unquote, in a sense. And I would say maybe not the right to life, but certainly privacy, because it is one of the highly debated issue in Taiwan, whether privacy has been violated, you know, in those effective measures that successfully control the pandemic on the one hand, but on the other hand, you know, infringe upon privacy. And because the Taiwanese government has been using, you can say, big data, phone tracking, you know, something like this, to, you can say, locate each and every Taiwanese, you know, where you are, you know, where have you been, you know, in, you know, 2 days ago or something like that. So once a confirmed case is found, the Taiwanese government can easily locate, for example, 10 square kilometers, who are in similar, restaurants, who were in similar shops, who were in similar, movie theaters and something, and force quarantine to those who are neighboring to those confirmed cases. And sadly, I think Taiwanese people generally accept what the government has done so far. And of course, many content scholars and privacy or information law scholars has questioned the legitimacy and constitutionality of such measures. But in terms of emergency or in terms of crisis, the calls for a robust judicial check or judicial protection of privacy is, frankly, it's not that popular. People would, I think generally Taiwanese people are willing to exchange their privacy for a more, I would say, I don't know, a safer places to live in, I guess. So, and that might, in your words, redefine the idea or the concept of privacy even after the COVID-19 was, controlled. So I guess that's my 2 cents. Thank you.
Thank you, Professor Sin. Since one opportunity for anyone who will ask the questions to the speaker or discussion. Okay, Professor Lee.
Yeah, hello. Okay. So just one comment on this Taiwanese case. So, for question. So in Taiwan, although the court mentioned proportionality, but the decree itself is constitutional, isn't it? Right? Okay. So it's very similar to Korean precedent, because in Korea we have precedent, and then court actually reviewed the case, but the result was constitutional. And then court actually focused on the procedural, limit, which is already, prescribed in the constitution. I think it's also similar to Taiwan. So even though Taiwan mentioned about the substantive limit, which means proportionality, etc., but actually it is not, deeply reviewed, right? It's tested. But in Korea, actually, as far as I know, in this precedent, proportionality is not mentioned. But they focus on the procedural, limit, which is already, in the text of the constitution. But it was, in 1996, so already old, very early decision. So that's why in times of 2020, right now, if this case is, also applied, this application in Korea Constitutional Court, maybe this is just my guess. Court will also mention at least proportionality, the standard at least. But if they really apply, this, test in depth, I'm not sure, because there is kind of discretion, right, of the government. So, but I just mentioned the difference in the case of the Taiwan and Korea. So in Taiwan, they have mentioned at least proportionality test, but we in Korea we haven't mentioned in 1996 decision. So this is my comment. Thank you.
Thank you, Professor Lee from Korea. And I think we have to close these discussions because of the time for breaking the fast. And I'd like to invite Professor Susi and Professor Lee for giving closing remarks, each of them about 3 minutes, and then closing statement, maybe either from Professor Susi or Professor Lee. Professor Susi, okay. Professor Lee, you have the floor.
Thank you, Professor Atip. Professor Ejima, then Professor Lin, Mr. Atip B. Ponsin, Mr. Chakim, And Dr. Lee, it is again my great pleasure to have a discussion with you. Even though that's very short discussion, but I have a numerous and various information about how government to handle COVID-19 from different countries. And we realized that each of countries will regulate or not regulate the tool of handling the COVID-19 from the discussion. For instance, Japan doesn't have a constitutional clause on the emergency power based on the historical experience maybe, and then Taiwan has a constitutional norms on this issue. However, Indonesia, I think, not only the president have the power to declare state in emergency, but also the president has the power to issue the emergency law. So I think here we are in Indonesia have made to have to make a very sharp control towards the state or the government, because we have two constitutional clauses. The first one that gave the power to the president to declare state in emergency, and the second one gave the power or grants the power to the president to issue the emergency law or emergency decree. And then from the discussion, we also learn about how how the court will handle the decree introduced in emergency situation. The Indonesian Constitutional Court play an important role, as well as the court from the others. So in conclusion, I think that we have, or each of the country has a regulation on handle the situation, the emergency situation, that, and this will depend on the historical and then the political context, as well as the human rights, maybe the human rights issue. That's what I want to say. And again, I'd like to say thank you to all of the presenter and the discussion, especially to Dr. Lee, who gave an opportunity for the Indonesian Association of Comparative Law to become the co-host. In addition, I also want to share my gratitude to Mr. Satrio, as well as to Mr. Wichak, who also kindly help or assist us to manage our evening discussion. Thank you.
Dr. Lee?
Yes, okay. Thank you for this, giving me chance this of closing remark. So just very briefly, so I hope this kind of discussion, so especially this kind of web discussion form, so continue in the future too, because I also presume that you also realize, and I really realize that this kind of web discussion is wonderful, and then it's a platform to exchange our ideas, and then it does not cost many much money, and also but also it's a really effective. And also this kind of comparative, this approach give us very good inspiration that we have learned a lot from this procedural limit, and also substantive limit. For example, prosperity. For example, in Taiwan, they also mentioned this one. I learned a lot today, and I really hope that. So since we have also other, topics like a privacy issue, for example, and then also we also can more also focus on all this issue, I mean, topic about emergency issue more deeply, focus on, for example, Korean cases, or maybe over, or like in Japanese cases in the future too. So that's why, so we can discuss more about this opportunity in the future. And then if you are also interested, you're welcome to our, scholars network anytime about this, to fight this pandemic situation. And I really thank you for all, the related people, including speakers and discussants, or our, assisting people, including, Mr. Satrio. Thank you very much.
Thank you, Dr. Lee. And I will not make a conclusions because Professor Susi and Dr. Lee have summarized and make a conclusive statements about the discussions this evening. And especially because I'm not a constitutional lawyer, so I have no authoritative power here to make a conclusion on this issue. But I think I have to thank you, especially Professor Susi, to allow me taking part in this wonderful discussion and very inspiring and maybe intriguing for the Indonesian government that's already issued the government regulations, law, yeah, which will criticize by most of Indonesian constitutional lawyers, especially Professor Susi. Thank you very much for your participating in this discussions. Hopefully we will meet again in another issue relating to comparative law, issue constitutional law, and as well as international law, maybe sometimes. Thank you very much.
Thank you, Professor.
Yeah.
For become moderator.
Thank you.
Thank you.
Thank you. Bye-bye.
Bye. Bye.
Selamat berbuka.
Selamat. Wah, thank you.
Selamat berbuka.
Thank you.
Thank you.
Thank you, Professor Ejima. Thank you, Professor Lim.